the first to know. Nsem-Pii TV.
The Chief Justice suspended CJ Torkornoo. Etimide Nsem akodom ECOWAS Court na ope reliefs on petition what they akodam mo senebeya normal the President of the Republic ejina so they are suspending as the Chief Justice no obetime nya akwanya na watimi break bounce no na afi where back to na dwuma wo ye na court no etimi edi nsem amano na Nsem-Pii TV etima bawra mu a the ECOWAS Court per ni dwumadi a wodi eboa the ECOWAS community no it seems say maame CJ Torkornoo ye ne last hope ana Nsem-Pii etima bawra mu a tete ye nse ka chese ye maame CJ Torkornoo ewo hope kese ho ena na nida so nyina akogina because per the Supreme Court ruling omode kotia no unanimously ebo ni nsem tugu se oni nyina so bia se the committee ya sete se omo hwehwe na asem mu no ne mra ekoso Ghana ha in the Supreme Court no na ni kwan se maame nsem ode koto no mbutugu se committee bitima ye nadwuma alongside the Supreme Court so can asem maame emuni yakum in fact oba bonten a press conference echechi nsemu the reason why ono ohu ni se emra na ekoso no enye mra ewo se this excellency ejina so e de suspended no per the committee petition omode ball no ene nsema omode ball ni nyina so ono no chese akwanya kra obenya na nkodie yi ne ho ano kra no omomfa ma no it has been on the side of the government of Ghana ono ena take decision based on the committee report omode abrena maame CJ Torkornoo so hu ne se enye substantial enough se eno ebetimi dia suspended no by this actions akoso no and whatever as media ko ECOWAS Court cause who ni say Ghana belonging to the ECOWAS community no the court betima boa because in recent cases no wo hwe the ejapa dealer nkofo bi time asem the court ma ECOWAS Court omo no masem omo kire se omo do masem de na ejapa deal no Ghana gold ho nsensem ema omunyina Transparency International ene integrity Ghana Integrity Initiative for omo anti-corruption coalition for omo tabli asem ko ECOWAS Court no ECOWAS Court mi di asem no ebo omo asem no tugui enti there has been instances this ECOWAS Court edi Ghana nsem bebre there are instances so ECOWAS Court etimi wuli against the government of Ghana no one particular case May 2025 wuli against government of Ghana in a landmark case involving such a prolonged detention of 30 members of the Homeland Study Group Foundation no mutimi award a total of $75,000 US no damages of violation and for on human rights fundamental human right and no the government of Ghana elusu that particular case I found is the applicants were held without trial or due legal process for extended periods for some over a year no arrest also on May 8th 2019 under Ghana's 1978 prohibited organization decree. Into each applicant biansa can $2,000 per year CD equivalent no compensation rate for the breach of their rights from the government of Ghana. Into it is one thing you could see said the ECOWAS Court very decisive omutimi demand the government of Ghana and omutimi butia the government of Ghana. And per this the court of Ghana and the Supreme Court no ye Mahama Getu Torkornoo ain't me residing the hope and in the trust in again no. It seems the ECOWAS Court today is the last hope to save a year Mahama Getu Torkornoo because from here no say ECOWAS Court no enya mana na say eya seems say na say Hague na ebeko, that is the International Court of Justice, na say e prolong but per the rulings at ECOWAS Court etimidi ema eye people omde omo eye applicants omde omo nsem ko ene ohwe nsem a ye Mahama Getu Torkornoo etimi release ya enuti same say a ona the deputy attorney general a release nsem bebre no per the terms are air cost chese ye Mahama Getu Torkornoo high hopes in the ECOWAS Court as compared to the Supreme Court of Ghana. Ono huni say it will be bound to her say ebeboa per ono reliefs are open. It seems say normal pushy His Excellency John Dramani Mahama, because the way the Deputy Attorney General seems like normal say ye Mahama any form I'll bet me petition as same way ECOWAS Court no train sembebre because ye Mahama di bema it will be ruling against the Supreme Court of Ghana about overturning events ama ye Mahama Getu Torkornoo etimenya attentene na open in this particular field. Now the ECOWAS Court ne mandate pa obetime gina so de abu ade na mama no, and he said Ghana are part of 14 other West African states, you know. Essentially court no is an organ of this particular communities here Ghana ye ka ho no. Court no betima act as adjudicative body no betima handle 4 main types of disputes, and those relating to the interpretation, application, legality of ECOWAS regulations, those that arise between ECOWAS and its employees, and those relating to liability for or against ECOWAS, and those that involve a violation of human rights committed by a member state. And these are 4 things that the ECOWAS Court ebitimi ejina so de ruli amaye Mahama Getu Torkornoo on these 4 principles, and answer 4 essential handles no ye Mahama Getu Torkornoo de no violation of human rights by a member state. It's a hopa na ye Mahama Getu Torkornoo edini normal ekosrea it is perceived say ye Mahama nsem a waka any ni evidences are buttress ni petition, you know, say per the rulings of the ECOWAS Court ye Mahama wo arreshimu papa enunti ohwa apusi the executive order, and as the executive arm of government ye papa John Dramani Mahama handle no. It seems a push forward one way the government of Ghana may lose this particular case now face damages ne compensation one way ebekwatia omono ano ebeyedinti per the grounds I am the ECOWAS Court holding in Ghana hano. These are some of the things that ebitima boitia the government of Ghana per a year omo handles omo teki, be it a year dispute related to interpretation of application, after so legality of ECOWAS regulations, and are those between ECOWAS and its employees, and some about a violation of human rights committed by a member state. Indeed, per these handles the ECOWAS Court holding it as ye Mahama Getu Torkornoo ewo arreshemu na afi so owonyina so pe normal waka ene pe ne petition a odi akoto omanim no na say government of Ghana wan hwe ya at the day obetua damages, compensation, any other remunerations or at the day no obetua ka nanke hu hia senka obetake this particular on, because per the laws of the Ghana no it seems say ma make to Torkornoo ewo nyina so kese na according to the ECOWAS Court no or the mandate no to ensure observance of law and of the principles of equity in the interpretation and application of the provisions of the Community Treaty and all other subsidiary legal instruments are adopted by its member states. In the ECOWAS Court there per emra its member state you find some employees any ade womu dwumayefo any ade nyina womu no omo regulate on all facets of the rights per omo dwumedi omodie. Nti if the government of Ghana ade betia an employee that is yema mege to Torkornoo on the advice of dwumedia na emra bo ne ho ban se onye na dwuma na se per the community engagement any laws bind the ECOWAS community Ghana ye involved no it means say yema mege to Torkornoo ewo nyina so pa ahwe ya Ghana government of Ghana any other degrees ni nyina ahwe ya na ebekwatia the government of Ghana which suspension of Torkornoo no unlawful any illegal na fe so wetimenya baby papa gina no back to as a substantive chief justice suspension ye papa a suspending no ohun ni say committee no by pamine ade any omo gina mu no enye right no ebetimi akwatia the government of Ghana. Nti some of the contentious jurisdictions are ekoso no ebi say the court no betimi examine case of failure by a member state to honor their obligations under the community law. After so court no betimi adjudicate on the competence of any dispute relating to the interpretation and application of acts of the community. And the interpretation, it seems that it is one of the major tools the ECOWAS Court etiki because someone to me interpretate a ye more particular jurisdiction na eba monasia they will go back to every aspect of it. I say ebeboa na emwa na omatimi edi attentrene edi ama the respective applicants and I say one be it the complainant and I say the plaintiff necessary Jumedia also mudi no omedi na court no so adjudicating in dispute between institutions of the community and their officials. Indeed, the court has power to handle cases dealing with liability for or against the community. And after the court no jurisdiction to determine cases of violation of human rights that occur in any member state. To these and now per the petition and answer complaints are ma make it to Torkornoo to ECOWAS community anymore. It is substance it is really based on human rights. Human right and also Ghana etime differ at ECOWAS Court penya per the history any precedents tima ko honoma omo mu taking some ko government of Ghana tima renibi in and out dan kwakufa do time no send them kan no nkofo wi omo tabiri asem ko ho no omulusu case no yes omulusu case no and after so there has been a case Ghana so elusu case no it is something yema make it to Torkornoo ejina ehu say this is a time ohun ni say the fundamental human rights no was otabiri asem no ko ECOWAS Court because ECOWAS Court has the mandate to do everything for her and in last hope I don't know who say it will be very important ebeboa no pe ne nsema wo ka no na Nsem-Pii wetima boroma hu say maame no ebetima nyina so amia overturn all emra ene rulings akoso etia na it seems say the hearing no in the natural course of justice and natural justice no was only a fair hearing on both sides or no who say on no side no there is no proper hearing going on baby obenya hearing the ECOWAS Court until the court no etimi adjudge on making declarations on a legality of regulations, directives, decisions, and other subsidiary legal instruments are the ECOWAS Court adapted in its administrative activities. Into details of the two applications are the suspended Chief Justice filed ECOWAS Court say Osiki Court one jurisdiction to determine cases of violation of human rights that occur in member states of the community. Ghana a part of it. Also, or contended the determination of a prima facie in the three petitions for her. The decision by the President John Dramani Mahama to suspend her and the actions of the 5-member committee set by the President, which are chaired by Supreme Court Justice Gabriel Scott Palmer, and any other and violating her human rights. And also a year to declare the suspension and the institution of the 5-member committee, as well as the rest of the committee violating the human rights. It is an kind per ECOWAS Court or mandate or mutimi a year juma on nipa human rights, meaning say yemame based on the petition or the down or the ECOWAS Court has the mandate to overturn things for her. Na se omuhim no mu say in some of can they are the rightful petitioner. At the end of the day, things will be turned and answer overturned. The jurisdiction Ghana ha Supreme Court ne Nsem-Pii the two and answer the ruling na omuko unanimous. Each and Nsem-Pii can be overturned to the favor of Mahama Torkornoo. We look forward to anything coming up because Srim Sai she say was started kasa ho a ne otim say omusu astarte eyi Nsem-Pii say omo based on normal my they are lawful and they are legal per Mahama Torkornoo and some of the akodan ECOWAS Court na say etwetwe so papa His Excellency John Dramani Mahama has a case to handle. Fact or case I was say or tikoyin is in the one enche the ECOWAS Court ebetna same we so we paid in some way Baba Banche say Mahama Torkornoo is seeking justice. I will say the law is the law. The in some way be here now anything that comes up in the coming future enche kura this ECOWAS Court betna same we so na or media sem na pay all the legalities so per every case I ba ne ade nyina ye mama so enti telebesia na mohu de wekoso.
Nsem-Pii TV nie